very pleased to introduce today's speaker, my friend Wadie Said, who is professor of law at the University of South Carolina School of Law. He's a graduate of Princeton University and Columbia Law School, and author of, among many other things, the book Crimes of Terror, published this year by Oxford University Press. Wadie, welcome.
Thank you, Jack, for that lovely introduction, and also thanks to all of you for being here in the California International Law Center and the IOP Center also for inviting me. Particularly, I'm honored by the affiliation with Keith Ioki, whose work has been influential on my own, even though I've never had the opportunity to meet him personally. So I'm very happy to be here and to talk to you a little bit today about my book, which, as Jack mentioned, is recently out with Oxford University Press. Given that there's a theme to the to this general series of talks and seminars, I'm going to try and kind of speak on my own work within this theme of surveillance democracy. So my goal is to talk about surveillance, a type of surveillance here that I'm concerned with. It's not the detached, anonymous type that affects all electronic communications throughout the United States and the world, in this sort of post-Snowden era. I think when we think mass surveillance, that's what we're rightfully concerned with. The type I've been covering, and I've written a chapter about it in my book, is a little bit more focused, and it encapsulates some of the troubling theories that are at the heart of what is called, or has been called, counterterrorism in the United States. But before I get into the sort of the more in-depth discussion related to the theme of the seminar, I just want to talk a little bit about the book so we can place my remarks in context. Forgive the long-winded title here, but the book's title is Crimes of Terror, the Legal and Political Implications of Federal Terrorism Prosecutions. And to see how the various chapters kind of all tie together, the book goes in a linear fashion. It kind of tracks a terrorism prosecution from its inception at the investigatory phase and then proceeds all the way on down the line to sentencing after someone has been convicted, and then even conditions of confinement. So after a brief introduction, I talk about the investigatory phase, and that's what I'm going to be focusing on today. The discussion centers on the use of informants and spying, as well as the entrapment defense and all the theories that go into that. As it turns out, the entrapment defense is no defense at all. But we'll come to that. The next chapter then talks about the main statutory device used by the government to bring prosecutions, that is the criminal ban on providing material support to a foreign terrorist organization, or, forgive me for using an acronym, an FTO. That presents a whole host of issues, and I'll touch on that briefly as well. Then I have a chapter on the generation and use of evidence by the government in a prosecution. Both forms involve departures from the normal rules of criminal practice. And then in the last couple of chapters, the first one is a kind of theoretical chapter that looks at the theory behind criminal terrorist prosecution in a general sense. And my specific case study there is the case of Jose Padilla, you may remember, as the so-called dirty bomber. And then the book concludes with a chapter on sentencing. There's even a special sentencing enhancement for people who are convicted of crimes of terrorism, and confinement. There are also, as the theme gets developed here, I'm building up to a kind of a discussion on exceptionalism. But essentially, there's also, in addition to all the kind of exceptional themes that run throughout the book, even as you arrive at the end of the line, even if prisoners, for example, or convicted prisoners end up being classified as minimum security prisoners, they can in fact be sent to a special unit that the Bureau of Prison holds, essentially created for terrorism prisoners, even if their crime is a sort of a minor crime that only involves a 2 or 3 year sentence, they can still get sent to a special unit where they're isolated from the rest of the population and their communications monitored in a far greater manner than that of a normal federal prisoner. So I'm documenting what I believe to be a kind of a terrorist exception or terrorism exception to the normal rules of criminal law and procedure, and that goes all the way along the book. Another key focus here is the distorting effect that the terrorism prosecution has had on American criminal law and procedure, and how that distortion has disproportionately affected those targeted. And here we're talking about primarily the Muslim community in the United States. So, placing that discussion properly in context, there are 2 kind of critical points to make at the outset that distinguish terrorism prosecutions from most ordinary criminal cases. And these 2 points will also play a role, kind of influence our understanding of the surveillance. You could also call it the overly aggressive or overly proactive, if you want to be more euphemistic, investigatory aspect here that feeds in again to the theme of the seminar. Now, the first point to understand at the outset is the emphasis in terrorism prosecution is, according to the government, on preventing acts of terrorism before they occur. And this is something that Attorney General John Ashcroft, in the wake of the September 11, 2001 attacks, explicitly adopted as a mindset that he wanted DOJ prosecutors to work with. And that's continued to guide terrorism investigations and prosecutions over the last 14 years. The preventive approach contrasts directly with the pre-9/11 approach, which was all about punishing individuals for acts that had been carried out, usually an act of violence. And we'll see that that's not the case anymore. And sort of what used to be a focus on punishing individuals implicated in politically motivated acts of violence that had already occurred has now changed. So, even though pre-9/11 terrorism prosecutions did offer some legal innovation and did sort of break the mold a little bit, the post-9/11 model has been something completely different. So, in the past, like ordinary crimes involving an act of violence and a link to the United States, now we see something new, because a focus on prevention ensures that violence need not occur before the government can charge someone with terrorism-related crimes. The link to a plot or an act of violence can also be highly attenuated, and certainly, I think it's not unfair to say, in the eye of the beholder. And an FBI agent and a federal prosecutor may have a different understanding of a plot than, say, I don't know, someone who's a former federal public defender who's defended terrorism defendants and sees things differently. But that's another story. Okay. So many of the prosecutions examined in the book, across the various chapters, they should be read with this preventive posture in mind, because I think it's fair to say that there are real questions about an individual's dangerousness if the government essentially comes in and construes someone as a threat, and all they've been relying on is not an actual record of carrying out crimes or actual kind of proof linking to a violent plot in the making, but rather someone's statements on, say, political statements on a given series of current events, or their religious activity. We'll see that also comes into play, or even just statements made in confidence that have been overheard by the government. As I mentioned before, the nature of the terrorism threat, which the government views chiefly as a Muslim threat, I believe it's been greatly exaggerated, and the preventive paradigm has contributed quite significantly to this exaggeration. So, for example, in the first decade after September 11th, one of the statistics I think the most reliable statistic was almost 95% of terrorism-related convictions recorded by the Department of Justice were either preventive prosecution cases or cases that involved elements of preventive prosecution. So the plot was, at best, not near fruition. And in many of these cases, we see the government has played a central role in creating the threat. So I think it's fair to say that if we look back on the record, there are real questions that have been raised by these prosecutions, not merely about an individual defendant's dangerousness, but also about the national security need for the erosion of rights that courts have repeatedly approved. Okay, so that's the sort of the preventive model in a nutshell, and the effect it's had. That's the first point. The second point, or second major innovation in the post-9/11 world involving terrorism prosecution, concerns the use of a statute known as the criminal ban on providing material support to a designated FTO, foreign terrorist organization, in the statutory designation 18 U.S.C. section 2339B. And this is the government's chief statutory tool that underpins many of the cases that I discuss, in the book. It's important, I think, also to have an understanding about the material support law, as I will probably refer to it in shorthand. Because of its origins and because of what it's become, and also how it feeds the mindset of prevention and feeds into the mindset of prevention and allows the government a legal tool to kind of go in much earlier than we would normally expect in a kind of a criminal investigation. So when Congress passed the law in 1996, the focus was on the problem. I mean, I don't think it was a real problem, but let's say the purported or supposed problem of what Congress believed was terrorist groups raising money for violence in this country under the cover of humanitarian activity. So Congress believed that there were groups operating in this country that were saying, come give money to us. And we'll make sure that the money will only go towards humanitarian ends. Okay, let's say I'm wrong and the concern wasn't exaggerated at the time, and that there was a need for this law, which in the book I sort of allude to the fact that I don't agree with it. But let's just leave that aside, my silly opinion notwithstanding. Let's just say the need existed. What is undisputed is that the concept of material support at the time in 1996 was centered squarely on the issue of tangible contributions, money, weapons, equipment, etc., that aid directly in an FTO's violent mission. Okay? So the idea being, and Congress actually made this finding, it made two critical findings. One is money is fungible. Money for humanitarian activity frees up money for weapons. Okay, so that was one key finding. Another was that Congress determined that terrorist groups, and I'm not going to talk too much about the designation process because I don't know that I have time today, but I'd be happy to talk to whoever would like maybe afterwards. But essentially, Congress made a finding that terrorist groups, once they've been designated, are any contact group is toxic, right? They're so tainted by their violent activity that any support can be criminalized. So as envisioned, the statute allows for the prosecution of individuals contributing to an FTO, foreign terrorist organization's efforts, several steps removed from violent activity. So here we see the concept of terrorism being broadened to encompass support, and who that support, or who terrorism taints by association. So the law was geared specifically to deal with individuals motivated by purely charitable or altruistic concerns, and so they are not spared the law's predation. And we see, if you look at the record of material support prosecutions, we see several cases in which individuals have been convicted and sentenced to long prison terms for engaging in what they believe to be purely humanitarian activity. Okay? And Congress has said that was precisely the point. Conviction and material support charges can bring, it used to be 15 years in prison, now it just was amended in June of this year to be up to 20 years in prison. Now, the years since the passage of ban have seen the courts further widen the concept of material support. So we're not just talking about money anymore. We're also talking about, for example, in 2010, the Supreme Court actually ruled that the government could go after people who provide material support in the form of speech. So, in that case known as Holder versus Humanitarian Law Project, essentially individuals who, for example, wanted to help a group on the FTO list, they gave the example of lobbying the U.S. Congress to get taken off that list, and provide expert advice and assistance on how to lobby Congress effectively, thereby diverting them from their violent mission. No, that can be criminalized as material support. So we've gone from money is fungible to speech. Even more troubling in a well-known case out of the Northern District of Texas involving the officers of the Holy Land Foundation for Relief and Development, which at the time was the largest Muslim charity in the United States. They were convicted on the theory of providing material support in the form of legitimacy. The group that they had been supporting was not tied to violent activity. It wasn't freeing up money for violence. It was enhancing the reputation and legitimacy of the terrorist organization in the eyes of the public where it operated. So the theory of material support has gone, I think, has expanded. I'll put it like that. So now what we see is not only is the terrorism prosecution's aim preventive, with all the attendant difficulty that brings of us knowing sort of before the fact, after the fact, when an attack is truly thwarted or a dangerous individual actually deterred, but it also relies principally on this concept of material support, which, as I've tried to detail, is a nebulous notion that can have the effect of criminalizing association and political/religious affiliation as terroristic. So these kind of critical introductory points, I think, allow us to see how the government might turn to more proactive and prevalent and invasive surveillance, given that the link to violent activity has become rather attenuated. After all, the material support ban also, I think a point that's worth noting, focuses on support as the crime, not the crime itself, not murder or assault or whatever it is, but the actual support being criminalized. And you don't see that in the criminal law. Okay. So turning more directly into the kind of surveillance regime that we've seen take place in connection with criminal terrorism prosecutions. We have, in this country, I think, seen two kind of bigger phenomena. One is the government's over-reliance, the federal government, specifically the FBI's over-reliance on the use of informants to drive criminal prosecution. We've also seen a wholesale spying regime enacted by the largest municipal police force in the United States, the New York City Police Department. So I'm going to talk about both in turn, and with a little bit more of a focus on, while I'll initially focus on the NYPD, I'll then turn to the FBI. But I think it's important to note, and I'm not going to talk about it as much as I do in the book, but it's important to note that this entire surveillance regime, okay, is undergirded by something called, and you may have seen this in the news, you may see this kind of phrase thrown out, it's the theory of radicalization. I'm sure some of you have heard that, if not most of you have heard the phrase that someone was radical. Okay? They were radicalized, and that's when the government had to step in. Well, when you look at the phrase, now before I make these remarks, I just want to say, I don't want to, in the past I think maybe in talks, I don't know, maybe I've gotten a little carried away. Maybe I've made claims that I couldn't always back up, maybe spoken a little too categorically. So let me say that I want to make clear that I'm not denying that people become radicalized, and I'm not denying that there are violent individuals who would wish us harm. I'm not trying to pretend that we live in a world free of any threats, and we should accordingly drop any and all attempts to protect ourselves. Likewise, there are people who become radicalized. I think that's fair to say. But as with, I think one of the goals of my work in general over the past, say, 10 years in studying terrorism prosecutions is to look at the claims the government makes and subject them to some scrutiny to see if they're borne out or not. And I think that they're largely exaggerated. So to the point on the radicalization theory, what we see is that there are two kind of foundational reports that flesh this theory out. So in 2006, the FBI came out with a 20 or 30 page report, authorless, no author on it, so we don't know who actually wrote it, which discussed the theory of radicalization, and they use concepts, and it uses concepts like the 4 phases of radicalization: pre-radicalization, indoctrination, etc. In the case of the FBI, the radicalization report, because we don't know who wrote it, is still in effect. So FBI agents still use it to kind of track their targets, and they put them sort of like almost like a formula. Okay, is this person in the pre-radicalization? Are they in the indoctrination phase? Or in the preparation phase? Are they in the action phase? Or whatever terms they use. In 2007, the New York Police Department issued its own report, kind of expanding on the FBI report. And in this case, we actually know who wrote it. One is a police analyst we don't know much about his background, but we know his name. And the other is a fellow who was working for the New York Police Department. And after September 11th, by the way, the New York Police Department came up with its own intelligence department. So they said, we're not going to trust the FBI to combat terrorism. We're going to, in fact, have our own intelligence department and work on our own to do these things. And so the NYPD report is even more detailed. The guy who we know about his background who wrote it doesn't have any training in Islam or in any of the cultures or languages of the Muslim world. He's in fact, I think, a risk analyst in an investment bank or something like that. So this report, which created a whole-scale spying regime, basically operates like a racial profile. I mean, it says stuff like, who's the target group? Young Muslim men between the ages of 18 and 35. But it can be sometimes women. Can't discount women, all right? Who are the people who are most susceptible to being radicalized? People who are down on their luck, who are angry at the world, maybe angry at the United States. But also successful Muslims as well. Did we say Muslims? Yes, we did, actually. That's the way the report works. Kind of covering its tracks and trying to appear sort of neutral, but really focusing itself. So it's a kind of a fancy dress, if you ask me, racial profile, which as we've seen, the government, the Department of Justice actually at the end of last year finally issued regulations saying that we're not going to use racial profile anymore. But radicalization, which is now morphed into something called countering violence, violent extremism, kind of an exception. It's kind of an exception given that it's still in use both in the federal context and in the NYPD context to a degree. There have been some changes. But what ended up happening was in New York City and its environments, the police were engaging in activities like the following. They were sending informants into mosques. Just no pre-existing suspicion that the mosque had any ties to any violent activity or was dangerous in any way. They send them in. They had a name for these people. They called them mosque crawlers or rakers. Okay? The theory was that a mosque could be something called a terrorism enterprise. Okay, and we have, because of lawsuits, we now know that various New York City police officials said, hey, mosques are different. They're not like churches. They go and they pray there 5 times a day. So there's more stuff going on there than in your average house of worship. How that statement can be subject to scrutiny, I don't know. Okay? But the main thing is, even as the New York Police Department spied on the entire Muslim community, and interestingly, they made use of police officers and undercovers of Muslim origin to spy. The authors, of course, who came up with this theory, they didn't bother to consult with people who knew anything about the religion or religions of the people they were to spy on. But don't let me harp too much on that. The main thing is, despite this massive regime, it never ended up working. It didn't produce one single conviction in the several years that it was operational. Okay? And the NYPD finally said, we're going to disband the unit that's doing the spying, as lawsuits broke out, etc. It was a kind of huge fiasco. But it shows that the largest police department in the United States viewed an entire section of the city as inherently suspect and acted on it and convinced courts that this was legitimate and actually got a court order allowing it to do so, even though it never really worked. Okay. The FBI's method is different, and it works in 2 ways. And we now see that the NYPD has actually come more into the FBI's model, although it hasn't disavowed what it did. It's just temporarily disbanded it, so if there's another crisis, it could engage in wholesale spying again. But the FBI's method is different. It uses something called an assessment, or assessments, and then also informants. So what are assessments? Assessments are basically, they demand a very low factual predicate and basically allow the FBI to open a kind of low-level investigation of even just basic legal activity as a precursor to what has come to be known as mapping a community. So FBI analysts can say, I wonder how many mosques there are in the state of California. Okay, so they go and they get that information. Does it lead to an investigation? Does it lead to a prosecution? Doesn't have to. Doesn't have to. But they'll open up and they'll get that information and then they'll retain it in their records. Okay, so it's something that's sort of outside the purview of what we in the public, the general public, know about. Okay, so for example, to give you an example, in the 2-year period between 2009 and 2011, there were 443,000 assessments open that were national security related. And the vast majority of them don't lead to any actual investigations or prosecutions. But the FBI retains that information. So it's creating a map, as the phrasing goes. It is mapping the country for national security threats. Okay? How many people of Algerian origin live in the greater Los Angeles area is something that they could look into. Okay? And keep it in their records. And as a result, that process is kind of twofold. It relies on informants going in and saying, okay, we went to this mosque and most of the congregants are Algerians, so we can say that about 500 Algerians live in this area and use this mosque, something like that. But it also allows informants to then go, well, we're actually concerned about the Algerian community, so let's send an informant in there, or let's send an undercover in there, or let's send an agent there to see if someone wants to work with us, to spy on the community. So it's kind of twofold. And once the government has mapped the community, it can then, in creating informants, if it doesn't get the result it wants, it can use other means. So, for example, in the case of an individual of Iranian origin who was an imam, a religious leader, in South Florida, the government approached him, the FBI approached him and said, we want you to work for us as an informant. He said, okay, let's do it openly, so everyone knows I'm working with the FBI. They said, no, we want you to be a covert informant. He said, no, I don't want to do that. The next thing you know, his case for political asylum in the United States was being thwarted, okay, and there was a problem. Another fellow, an Egyptian, whose cousin had been an Al-Qaeda operative, was pressured to be an informant. He said no. The government also thwarted his attempts to become a U.S. citizen and continued to do so even after his cousin was killed in Afghanistan. Okay. In one of the more well-known cases, there was an Egyptian American who was charged and ultimately convicted of material support charges for, among other things, translating some documents and putting them on the internet. The government alleged it was in cahoots with Al-Qaeda. But he basically said, I'm being prosecuted because I refuse to become an informant. Okay? So the government can use heavy-handed tactics. Another tactic we've learned about is the use of the no-fly list. So individuals who refuse to become informants, they find themselves on the no-fly list. By the way, when they sued about that, the government took them off the no-fly list, but it refused to change the way it used the no-fly list. So they're continuing with their lawsuit. Some individuals who've been abroad, American U.S. citizens who refuse to become informants, have been held and tortured. That's my phrase, so if you don't believe me, that's fine. Beaten by foreign intelligence services in the Emirates, the United Arab Emirates, in the Horn of Africa, East Africa. They've sued but haven't received much relief in U.S. courts. Again, these are the tactics the government uses to create informants. But that's not every tactic. That's not every case. And in a typical criminal prosecution, we see the informant who doesn't, again, operate with any pre-existing suspicion. They don't say, well, we have information that something is funny in this particular community. The government just sends them out. The pattern is that of informants who often suggest a plot and prey on their weak targets, and then provide the means to carry out the violent plot. So we've seen now in the post-September 11th world, from a number of around pre-September 11th, we're talking about 6,000 or 7,000, I think. Informants, now we have something like 15,000 or 16,000 informants that the government has admitted to having in the post-September 11th world. This is in a situation where there are some conflicting studies about this. One says 1% of all terrorism prosecutions represented an actual violent threat. Another study says 3% represented an actual violent threat. That is to say, without the actions or involvement of the government's informant, independent of the government informant. But those are pretty low numbers. Those are pretty low numbers. And the informants themselves operate in kind of a suspect manner. So, for example, I don't know if some of you may have seen, for example, on HBO there was a movie called The Newburgh 4. Did you see this documentary? Anyone heard about it? It's something you might want to watch. The informant in that case, basically a fellow of Pakistani background who's basically a sort of a low-level criminal. He ended up getting ensnared by the government when he was working at the Albany, New York Department of Motor Vehicles, and he would basically offer to take written tests for immigrants who couldn't speak English for money. And when he got caught, he was looking at being deported from the United States as a result of his criminal charges. So he said to the government, well, I can help. I can maybe work for you somehow. He said, you want to be an informant? He said, sure. So he, in more than one case, the movie talks about his work in Newburgh, New York, entrapping a bunch of, I can say entrapping, you don't have to believe me again, but entrapping a bunch of men who were down on their luck to carry out a plot to blow up some targets in the area, a National Guard base and a synagogue in that area. In a previous case, he had sort of glommed onto a Bangladeshi pizzeria owner and gave his children gifts and worked very hard to get him to, it was a very kind of complicated plot, to launder money so that he could buy a missile to shoot down the Pakistani ambassadors to the United Nations plane. The whole thing was far-fetched, and it was characterized by the informant, who was from Pakistan, whose main language is Urdu, speaking to the pizzeria owner, who's from Bangladesh, who spoke a little Urdu, but his native language is Bengali, and speaking to each other in Urdu and broken English. And, you know, things like the word missile, they couldn't even agree on that because the informant would come in and say something like, I haven't, literally like that. And of course the pizzeria owner didn't understand what was going on. Yet he was in the end charged and convicted. So the informants operate without any pre-existing suspicion and target individuals in the Muslim community. And the problem is there's no real defense here. In that entrapment itself is not a defense. Because in an entrapment situation, what a court and or a jury is looking at is whether a defendant was so-called predisposed to commit the crime. So, for example, a drug dealer who's been totally railroaded by the government is going to have a hard time saying he was entrapped because he has all these drug convictions in his background. He's predisposed to commit the crime. It's kind of a flaw in the theory here. So there hasn't been one successful example of the entrapment defense since September 11, 2001. There are also other factors that investigative journalists like Trevor Aronson and Murtaza Hussain have uncovered in that, for example, in numerous cases, the critical conversation where the target agrees with the informant to carry out the plot, the recording equipment fails. So the government has thousands of hours of tapes of the individual, the informant and the defendant talking back and forth, et cetera, about all number of things. But the critical conversation where they actually agreed on the plot, well, the equipment malfunctioned. Interesting, given that the FBI's national security budget is now north of $4 billion and dwarfs its own law enforcement, regular crimes budget. You would think they could buy properly functioning equipment, but what can I tell you? This has led to a situation where, as one scholar has argued, basically the government's obsession with informants and obsession with mapping communities has led to a situation where the focus on these plots that the government creates has diverted attention from more serious situations. One scholar made the argument that the Boston Marathon bombing went undetected because of the over focus on sting operations and entrapment. Okay? So basically what we're seeing, and I'm going to wrap up here in about 2 minutes. Basically what we're seeing here is a change in the nature of the investigation / undercover operations in the political context to overturn the sort of post-late 70s, the Church Commission, Senate, and High Commission in the Senate and House. There were high-level, as I'm sure many of you know, high-level hearings and reforms enacted by Congress to change the nature of political spying, because the FBI and NYPD and other groups like the Chicago Police Department had been engaging in these large practices of spying on peaceful dissident groups or kind of social movements. And there was a real concern that the government needed to stop doing that. Okay? So what we're witnessing is a change, and that balance that was struck in the late 70s and early 80s has been kind of undone. And the government has kind of pushed very hard to have it undone. Okay? Additionally, what we saw is in the ordinary law enforcement context, there was a great deal of scrutiny and criticism of the use of informants in general, the phenomenon of snitching. And there's a professor at Loyola Law School in Los Angeles Alexandra Natapov, who wrote a whole book about it. A very trenchant critique of the problems of snitching. Well, the government has kind of shifted. Okay, well, we're going to sort of dodge the criticism there and refocus our efforts on national security. No one can really argue with that. And the tactics have come back. And I think Professor Joe of this faculty and Professor Jew of this faculty as well have written now about the problems with undercover policing and stings, a lot of which have been influenced by the reintroduction of the tactics in the context of terrorism back into the realm of ordinary law enforcement. We've now seen, for example, the Occupy movement has been spied on. The Black Lives Matter movement has been riddled with infiltrators, etc. We've also seen things like unrelated, but the terrorist kind of the terrorist experiment or terrorism investigation experiment has served as a model for example, the Drug Enforcement Agency has been making extensive use of stash house stings. So what they'll do is they'll say, here we have, go to a bunch of individuals and say, criminal targets, and say, hey, we heard there's a stash house, 158th Street in Upper Manhattan, on this apartment. All you need to do is just bust in at this time. Nobody will be there, and you can walk off with $1 million worth of cash and drugs. So they go in there, armed to the teeth, and there's the DEA. Very dangerous situation. In addition, and this is perhaps most surprising / distressing, we've now seen the federal government has kind of repurposed to make extensive use of undercovers. So we see, for example, the Department of Agriculture, the IRS, and the Small Business Administration now all have their own units of undercover police inspired by the terrorism context. Now, they're mostly investigating fraud. I'm not trying to kind of over make the case, but this has all been inspired by the war on terror and the government's use of informants and undercovers in that context. Perhaps most distressing, the Supreme Court police. I wasn't aware that there was a separate police force for the United States Supreme Court, but there is. Have been sending undercover agents into the protests in front of the U.S. Supreme Court to find out what they're demonstrating about and to see if any threats emerge. Okay? So the mindset, the investigations, the surveillance, even if not always high tech and the Edward Snowden type on a keyboard, infiltrating any email account anywhere in the world, has become the norm. What we're seeing, I think, is the FBI has become akin to a domestic intelligence agency or an internal security agency, something you might see in a police state or a dictatorship. And when was that authorized? When did we as a country have that discussion? I would like to conclude by asking if that's something that we're comfortable with, and stop there to take any questions. I hope I haven't gone too far.